Good afternoon, everybody. Since the time allotted to us about only 1 hour, and the subject matter is so interesting and challenging, I propose to dispense with the introduction of the speakers about their CVs and all, because they are already illustrious people here. Everybody is known. So I save some time on that. And what we propose to do is, each of the panel speaker here would make an introductory speech or a presentation for about 3 to 5 minutes. And thereafter, I have a lot of questions to ask the panelists and also to the audience. And that way I think we can have a good interaction among ourselves. There are lots of questions to be asked and answered. So with this, I straight away request Pratibha to start her presentation, and let us limit ourselves about 5 minutes, and then we can ask the questions.
Mr. Lakshmi Kumaran and the panelists on the dais and the audience, good afternoon. I'm going to quickly run through, otherwise I have given the permission to Mr. Kumaran to stop me at 5 minutes. Okay. Thank you. Before I start my presentation, I want to disclose that I have represented a number of innovators in the standard essential patent space, and but I do feel that this is important before I start my presentation. We are discussing interface between IPRs and competition law in the area of standard essential patents, which is, according to me, one of the hottest topics India is debating today, in the courts and in policy, in the corridors of government, in the corridors of regulators, and in the industry. So let us see how it spans out. Excuse me, how do I do page down? Okay, I've got it. What is the common purpose of IP in competition law? And I don't think I need to dwell too much into it. It is to build a competitive environment, but to promote innovation, right? In 2 words. The basic concept of IP could be an antithesis for competition. But IP as a policy in India and in the world is here to stay. Change in policy should first assess the market conditions. Is there a need to change? Or is there a need to change competition law or IP law to balance competition? That's the question. Let's look at the state of the smartphone industry in India. India has more than 60 mobile phone vendors. Not a single Indian vendor manufactures in India. Not a single Indian vendor owns any patents. Most smartphones are only imported and sold. We only market phones. The only employment we create is of advertising and marketing personnel. Where are the thousands of electronics and telecommunications engineers being employed by Indian vendors? Where is the research and development? Where is the innovation? Don't we have the capabilities? Don't we have the capital? We do. We have the engineers, we have the capabilities, we have the capital. But we still choose to import. What is the contribution of Indian vendors to the Indian innovation ecosystem? What is India's contribution to standards? Do we take part in discussions relating to standards? Even Indian bodies which are now being created for creation of standards are driven by the innovators. All innovators who own technology have made huge investments in India. They have generated employment in India. They have set up research and development centers in India. Instead of collaborating and adopting best practices, as a country we wish to hang the sword of competition, investigations on them. Let's analyze the market. Before the US and EU started investigations against companies, they built the IP ecosystem. They set the standards and then we followed. Look at the overall share in India, in the market. And it's so completely glaringly different when you look at the world share. Samsung is the highest, 17%, Micromax 14%, Nokia 10%, Carbon 9%, Lava 8%, 42% others. So out of the top 68%, there are 4 Indian players who are selling in India. Look at the world. Samsung has 31%, Apple has 15%. There's a huge gap. It's double. So therefore, there is competition in India. There are a lot of players in India. The prices are amongst the lowest in the world in India. Is there an issue of competition? That's the question I want to ask, first of all. In my view, there is no issue of competition. Smartphones are there in India. They are at the lowest prices, 5,000 rupees, 4,000 rupees. You don't get these prices anywhere else in the world. There is enough competition in India. The roadmap for India, in my view, is collaborate with technology owners, set up manufacturing bases in India, adopt the best practices in manufacturing qualitative products, make use of incentives provided by the government, create employment. India should not be the consumer and importer of smartphones, but a net exporter of smartphones. Out of 7 billion smartphone users in the world, 3 billion are in India and in China. What are we doing as a country to manufacture these phones in India? Have we done anything? No. Don't treat technology owners as foes, but as friends. Invest time, money, and effort in positive cooperation instead of negative publicity. Please put yourselves in their shoes. What is the choice for an innovator? There is this huge debate world over. No injunctions in standard essential patents. Okay, no injunctions. Then what? Royalties? Are they willing to pay royalties? Please ask the question. If no royalties, then they'll all be in litigation in courts for the next 5 years, 10 years. Whereas in the next 5 to 10 years, we can be the manufacturing hub for smartphones by assimilation of technology, by technology transfers, and by collaboration with technology holders. It's counterproductive to keep litigating continuously. It reduces the incentive for innovators to participate in the growth of India as a nation. For Make in India and for Digital India to succeed, technology assimilation is the key, and therefore collaboration is the way forward. Innovators are key partners. In my view, the debate on competition begins at the finish line of innovation and not before that. India has to mature before we talk of IP and competition. Let's create innovation before we talk about competition. Thank you.
You have done a good job and doing fine. Gupta, please.
Thank you, Pratibha, for that wonderful start. And I'll try to build upon that. And first of all, thank you for the organizers for having me here and for all of your participation and presence today. As Pratibha really laid out well, the dialogue on the intersection of competition and IPR is really just beginning to evolve. And while you'll hear multiple perspectives here today and how front and center it has become, in particular in India, but also in other jurisdictions, I wanted to say that I thought my role here could be to talk about the nature of the beast, if you will. What is standard setting? What are the innovators doing? And why is that essential for the health of the industry and for that industry to grow and evolve in India? I focus primarily on the mobile industry, not least because that's my home industry, but as you heard in the previous talk, that's this smartphones and tablets, that's really where this debate is centered right now, and because it's such an important part of our economy. So I'll talk briefly about standards, and the fonts are a bit messed up, sorry about that. Hopefully you can follow. What happens in the ICT industry is the following, right? Our technology develops in multiple stages, and this is really important to remember because without investment in innovation and the downstream technology standards, there wouldn't be a vibrant industry to begin with. All the devices that you're using today, your smartphones and tablets and the Wi-Fi networks that you're connected to, all that's possible because firms came together in the self-organized industry, invested in standards, solved really complex problems, anticipating in many years in advance what could be a market demand for that technology, and put their investments on the table, billions of dollars of investment on the table. So these three stages that I'll talk about briefly are the following. First, many years in advance, the industry needs to develop technology standards and invest in R&D. Then the development of standards compliant products starts, the smartphones and the tablets. So if there wouldn't have been those standards or those core technology solutions, there wouldn't be these products that implement those core technology solutions. And finally, network operators like service providers, they go and deploy these networks. And as we go down these stages, you can imagine what the investment and risk would look like. So that's in the timeline is the evolution in technology development. When we start investing in standard, we are facing multiple types of risk. One is inter-standard competition. When we are investing in standards as innovators, we don't know, the firms that are investing, they don't know whether their technology solutions may or may not be killed by a competing standard. They also don't know whether the markets will adopt their technology, whether they anticipated that market adoption in advance. And there are many examples of that. WiMAX is a standard that failed because of inter-standard competition. Digital video broadcast failed because consumers just didn't like to watch TV on their phones as much as we thought they would. Anyhow, when we roll into the future, the second stage of the technology, these risks are mitigated somewhat when people start developing products, because at least by now the inter-standard competition risk is gone. It's mitigated, reduced from the table. And in the stage 3, when operators start deploying these networks, there's much more of a sense of what the market adoption is going to look like. So it's important to recognize that in order to incentivize innovators to contribute key technologies into these standards and seed the industry, we must think of incentivizing risky R&D by rewarding that type of an investment. And secondly, I wanted to share a sense of what are these standards bodies doing and what is the scale of this type of an investment that I'm talking about. So I'll share with you some data from the 3G and 4G wireless standards body, and we all use those standards in our phones today, revealing this self-organized industry that's creating an ecosystem where firms are coming to the table and determining how to best solve these very complex technological problems. And the data shows that there are hundreds of firms barely make phone calls and some data connectivity, and that data rate and the quality of communications has simply exploded over the last decade or so because of these really complex technologies that were being produced by these technology standards. And they have enabled our ecosystem. They have enabled other firms to come in and to innovate over them to produce these types of applications that we all use in our phones today. So we are living in this era where it would be hard to find an industry that is more competitive, more dynamic, more successful than the mobile wireless industry. And it has been made possible because of investment in standards, because of incentivizing innovators and their investment in R&D. So I just wanted to stop here to provide that background and let the discussion continue. Thank you.
Thank you, Kirti. Very good.
Mr. Lakshmi Kumaran, my fellow panelists, ladies and gentlemen, I'd like to make two broad points this afternoon. One on patents or standard and essential patents, and two on a perceived jurisdictional conflict between the controller of patents, the CCI, the Competition Commission of India, and a civil court that would hear a suit for patent infringement. And these two broad questions are, do patent proceedings involving standard and essential patents need to be treated any differently than any other standard suit or proceeding for patent infringement, considering that our Patents Act and indeed patent legislations around the world make no special mention of standard and essential patents being treated in a special manner. So consider, for example, the standard rules that operate in the context of patent litigation. Ideally, there are no ad interim or ex parte injunctions granted in patent proceedings, or at least that is a rule that ought to be followed. Where there is a credible challenge to the validity of a patent, an interim injunction ought not to be granted. When the patent is a young one, a patent which is young and untested, once again, an interim injunction should in normal course not be granted. In the context of standard and essential patents, where the suit itself is really one for a money decree, where the patentee is saying that anybody who's willing to pay a license fee as determined by me would be granted a license, wouldn't Section 41 of the Specific Relief Act act as a bar to the grant of an injunction? Why is it that in the context of an SEP, there is an argument that is often placed in court that if the validity of the patent is challenged, then the defendant who so challenges the validity of the patent is considered an unwilling licensee? If these are, ladies and gentlemen, the standard rules that would operate in the context of a traditional, conventional patent claim, then why is it that pending trial, a defendant is asked to deposit in court large sums of money as security? In which IP proceeding in our courts do we see a defendant, particularly considering that the scope of the claim could essentially be a monetary one, be asked to deposit in court, pending trial, substantial sums of money that could have the result of crippling a particular company? The other point that I want to make is with respect to this perceived conflict of jurisdiction between the controller of patents on the one hand, the Competition Commission, and a court that hears a suit for alleged infringement of a patent. A civil court that is seized of a suit for patent infringement essentially decides questions of validity of the patent, whether the technology in question is essential, and perhaps consequently if there is infringement. And if validity and infringement are established, what monetary consequences should visit the defendant? In stark contrast, the scope of inquiry of the Competition Commission is vastly different, because the Competition Commission is not concerned with the validity issue or the issue of infringement. The Competition Commission is concerned with whether there is an abuse of a position of market dominance, resulting in competition being hijacked. So you could therefore have a situation where in a patent infringement proceeding, the patent is held to be valid, the technology is considered to be essential, and infringement is established. And yet the Competition Commission may still come to a finding of abuse of dominance. So I fail to understand where a conflict of jurisdiction could arise. I therefore would submit that standard and essential patents, or patent proceedings involving standard and essential patents, are like any other subject matter and ought not to be given a special status, which I am afraid we are hurtling into. Thank you.
Good afternoon. My name is John Matheson. I'm the Director of Legal Policy for Intel Corporation based in Singapore. Intel is the holder of many standard essential patents, and Intel is also a licensee of standard essential patents. So being on both sides of the fence, we're very concerned to see that this system works effectively wherever we operate around the world. And it probably provides one of the most fascinating conflicts for IP and competition laws that you have to deal with. And it's evolving, and it's happening and playing out in India as it is in other leading jurisdictions around the world. But the patent system and the standards essential patent system is a very interesting one, because at the outset of a standards body's efforts to establish a standard, as my colleague from Qualcomm explained, it's a very complex process. So you've got companies bringing their technology to the standards body and saying, this is the best solution, and trying to get their patents into the standard. And of course, there's a lot of R&D that goes into that, a lot of money is expended. But at the end of the day, after that competition and after those arguments and after all that money is spent, you end up with one standard. And the competitors who tried to bring in other technologies or other solutions, they fall away. So you tend to have one group of winners and then everyone else. And the industry has to coalesce around that standard, because we can't have 15 or 20 different ports on the back of your computer. You want to have one. You want to have a USB that speaks to all of your devices. You want to have every technology that you use as simple as possible. So the standard system is very effective in delivering that outcome. But at the end of the day, because that competition has changed substantially, and everyone in the industry is now backing a particular standard, the fortunate players who happen to own those standards essential patents are in a quite delicate position. They need to recoup the money they put into establishing the IP, their R&D, but they also have to recognize and be respectful of the fact that they have been ordained this special position by the standards organization. And the principal tool by which that discipline is imposed is by the FRAND mechanism, fair and reasonable and non-discriminatory royalties. So in most cases, the owner of a standard essential patent promises that they will license that patent on fair, reasonable and non-discriminatory grounds. So that's the trade-off. And it's the potential abuse of that trade-off where all the issues arise. And if you look around the world, there's a sea of litigation now when standard essential patent owners are trying to recoup their R&D by charging as high a royalty as they can, and the licensees are arguing for the lower royalty they can. And that's a natural tension that happens in our system. But the courts have cottoned on to the various forms of abuses that have followed on from this. And the EU has led the way with a number of leading cases, and they summarized very well the types of abuses that happen with standard essential patents. Let me quote from the EU's policy paper. The issue is that you are de facto locked in once the standard has been set, and this gives companies the potential to behave in anti-competitive ways. For example, by holding up users after the adoption of the standard, by excluding competitors from the market, by extracting excessive royalties, and by setting cross-license terms which the licensee would not otherwise agree to had they not been in a position of having no bargaining power. So all of these bad behaviors are happening in the standards essential patent world. I'm not saying for a moment that my colleagues here are engaged in that. In fact, Qualcomm's name doesn't appear in any of these bad cases, which is probably says much for the way they operate. But if you look at these cases, you'll find that they're being litigated by very big names. Microsoft is defending itself, and Samsung obviously is a very prominent litigant in this business. And in the US cases, there's some very interesting precedents coming out of the litigation that I want to share with you just briefly. But firstly, let me just look at the EU decision in Motorola and Apple. This was a decision of a German court which injuncted Apple in relation to one standard essential patent and basically shut down their business of iPads and iPhones until Apple signed up to a license. And that license included terms that precluded them from challenging the validity of the patents they had been licensed. And the EU said that is anti-competitive. And they said that it's also anti-competitive for a standard essential patent holder to seek an injunction against a willing licensee. So the interesting thing about these cases is that if you're a really big company with a big pocket and a massive litigation budget, at the end of the day, you can resolve these issues. But what about the smaller companies that don't have that budget, that are starting up, that are trying to support Make in India and want to be innovators and want to be leaders in their markets? They need access to the same justice that those large companies get. And so I think the challenge here for India is to learn from international experience, to look at the bad acts, to try and establish how we can avoid small companies being saddled with outrageous royalties, and find some form of solution that's going to work in this environment. And finally, I just want to give you an example of what I'm talking about on the royalty side. In the US case of Microsoft and Motorola, when there was an argument about royalties on Microsoft's Xbox, there was the usual debate about what's the royalty level, what does FRAND mean in the context of this particular standard. And so Motorola Mobility was seeking between $3 and $4.50 per Xbox, between $3 and $4.50 per Xbox. That case was litigated, and millions of dollars later, Microsoft succeeded in a judgment that said that the proper royalty rate was 3.5 cents per Xbox. So 100 times different. So big companies are able to defend themselves. Our challenge, and I think my fellow panelists here, the issue is, can we come up with a solution that enables everyone in India to share in these opportunities without these outrageous litigation costs? Thank you.
Good afternoon, everybody. This is Imaura from JETRO New Delhi office, and today I'd like to explain the status of Japan with regard to the standards and the patents. First, I'd like to share the case law, which is decided in this May 16th of this year in the IP High Court of Japan, which is the case of Samsung and Apple. And this is, of course, with regard to the standard essential patent. And in this case, Samsung is the right holder and made a declaration for the plant. And then, in this case, this is a kind of remarkable case because the IP High Court invited public opinion with regard to this issue and how to handle and how to determine or how to interpret these issues. Then lots of comments came from industries, and finally the IP High Court made a decision on these issues. And there are lots of issues with regard to this matter, but today I'd like to focus on these three issues. One is the damages, and there is a dispute that whether this kind of case, the Samsung can claim the damages. And in this case, and whether it should be less than or equal to the value of license fees, which should have been given by the contractor when suppose it is signed. And of course, this is the result is yes. So Samsung can claim a damage as long as it is equivalent or less than the value of license fees. But the other issues is that maybe if the Samsung does not declare this fund declaration, and there is a possibility to claim the damages higher than this value of license fees based on this FLAND contract. And this case, the IP High Court delivered no. The Apple cannot claim damages which is higher than the value of license fees which had been got from the FLAND condition. But there is some exception that if the defendant does not accept or wish to be licensed based on this FLAND condition, there is still possibility that the right holder can claim the defendant which damages which is higher than the value of license fee. And the third one is that claiming injunction. And of course, this is as kind of a word dispute. And in the case of Japan, IP High Court said that basically in these situations, that Samsung made a FLAND declaration, then no, the injunction cannot be granted. And of course, there is some condition that first, defendants need to prove one, a right holder makes a FLAND declaration, and two, the defendant wishes to be licensed based on FLAND conditions, such as making some negotiation between right holder and propose some conditions or otherwise, basically in the patent law, section 100. The patent holder can claim the injunction. So basically, otherwise, the injunction is granted. And the reason this injunction is not granted for this case is that there is many debates whether the competition law is applicable or many discussions are done. Then, in this case, the IP High Court said there is a Mother Act of a Patent Act, which is Civil Code, and the Civil Code Section 1, Subsection 3, prohibits the abuse of rights. Then, based on this, claiming this injunction is abuse of rights, then prohibit this kind of injunction in the case of Samsung. So this is the case of the IP High Court, Samsung versus Apple, and there are several other cases. And what is important is that sometimes they get the patent, but it involves the reason for invalidation. So I'm deployed from the Japan Patent Office and working as a local representative and as an authority to grant a patent. It is very important for us to grant the patent which is really involves validity, and we need to refuse the invention which does not have the inventive step or novelties. So this is the effort done by Japan Patent Office for the better examination with regard to the standard essential patent. One is that we have signed several international authorities of the standard, and one example is that the sign with ISO, which is done in this year of May. And then actually this is the first IP office in the world to cooperate with the ISO and getting the standard documents from ISO and some other standard organization and store it in our internal databases, we have our internal classification to better prior such. And of course, we classify those documents and improve our quality of the examination in order not to grant such kind of inventions which involve the invalidity. And next one is that often the authority do not aware, but this kind of search key done by authority is checked by outsiders. So by storing these kind of documents inside, we can hide what kind of cutting-edge technologies that filed before IP offices. And it is not only for the domestic applications. The JPO is acting as an international international search authority of Patent Cooperation Treaty, and now India is also the one of the ISA. Then to store these kind of databases and keep such kind of cutting-edge technologies from the preventing from the invasion from third parties, the JPO strongly recommend to collect these kind of non-patent literature, especially this kind of standardized documents. And this is one. And this again, this issue is a huge problem in Japan as well. Even though we are collecting this kind of standard documents, some of them are kept in a very small party, and some of them are open to the public. So, it is very difficult, sometimes it's very difficult when it is open or whether it is open to the public or not. So now we are doing some research studies whether to clarify the criteria of this standard document is open to the public or not. So still in JPO or Japan is discussing these matters, and we would like to develop these issues with cooperating with India. Thank you very much.
Thank you, my fellow panelists. What is the discussion about the standard essential patents? And John talked about FRAND as also Ms. Gupta. And what is the difference between the normal infringement cases between a normal patent holder and a standard essential patent holder? When technologies or the trade or industry agrees that certain standards will be followed by everybody to get the uniformity, for example, 2G or 3G or Edge, etc. These are all various standards. They are all basically agreed because interoperability. If everybody was having their own methods of working, then you are not going to have a seamless operations. So therefore, these standards become necessary and everybody has to follow the standards for the common good. But if inventors come with inventions and these inventions actually lie in the standards, and since everybody is compelled to follow the standards, then there is a necessarily they will be infringing the patents. Then what happens? That means all the standard essential patent holders will always be enriching themselves with regard to royalty because they are compelled, there is no choice but to actually follow the standards. So therefore, these standard essential patent holders are obliged to give the licenses on a FRAND basis. John discussed this FRAND very greatly. That must be fair, it must be reasonable, and it must be non-discriminatory. Only then you can exercise your rights. When you are talking about the FRAND, now who will determine whether this particular license term which have been given or at least given to the various users, is it actually FRAND compatible or not? And we have really the panelists here, one from Intel and from Qualcomm. Both of them have just now said that they are either giving and also licensing the standard essential patents. I have some interesting questions which has been bothering me, and I thought I will utilize this time to get the answers for those. John, can you explain to me what would you say is a reasonable royalty? Because FRAND talks about fair, reasonable, and non-discriminatory. When do you say and how do you say a particular royalty is reasonable? Before you answer the question, I will load you further. Should it be based on the device sale price or the relevant component price to which the invention closely relates to? Because if in a smartphone, I'm sorry, I use the phone. In a smartphone, they can have at least about 500 to 1,000 patents. Out of them, Qualcomm may hold about, say, 25 standard circle patents. Intel may hold. Somebody else may hold. Ericsson may hold. Therefore, there are several patent holders who are all having standard essential patents. You as a user, you are producing, say Samsung for example, they are producing this phone, and since they have to comply with the particular standards, necessarily they will be infringing if they are not getting a license from them. But since the SCP holders specifically have to give the license on a frank basis, there must be reasonable. Who will determine the reasonableness? And while doing so, how are you going to take care of royalty stacking? Royalty stacking is a very big problem. She wants, I want the pie, say 0.5% of the sale price of the component or the device. John wants 10% because he has more number of patents. With the result, if all the patent holders come back and then say, I want so much, etc., it can happen that the royalty rate can be even more than the sale price itself. This is stacking. How do you avoid the royalty stacking? Should all the SCP holders on a particular device join together and then say, this should be the royalty rate and we will divide among themselves? So these are the questions which are appearing to me, and therefore, John, I would request you to answer these questions to me and to the clarification. You can start from here only. You don't have to go back and then. What is basically, on the first question is about reasonableness.
Mr. Chairman, I'm fearful that you have invited a 25-minute answer. So let me just be very brief on each one and then leave time for my colleagues to respond. On FRAND, what reasonable means, I think if this was easy, we wouldn't be in the fix we are now. It's intrinsically very complicated. But the courts are the best arbiter of what is reasonable. They have been dealing with damages forever. They've been dealing with licensing issues forever. So the courts have that expertise. So when they determine what is reasonable, they look at a whole host of different things. They will look at licenses that companies have for the same technology. But they've got to be careful because a FRAND encumbered patent is different from a everyday garden variety patent. Once you've made that FRAND commitment, the reasonableness and non-discriminatory elements of the test are very important. So in brief, I'd leave that to the courts. The abuses, of course, are dealt with by competition authorities. Secondly, whether the royalty is based on the device itself or the component is a very interesting question. And we are very strongly of the view that the licenses should be sought by the component manufacturer. If you make a Wi-Fi chip, and it may be a $5 piece of silicon, but if you obtain a license to that chip, you should be entitled to approach the SEP owner for that license. Because if you leave it to the machine stage, when you've got a PC put together and you've got a licensor asking for 2% of the price, they want 2% of the power supply, 2% of the DVD, 2% of a whole group of components that they have made no contribution to. So we think the fairest solution is at the component level. And the third one is the royalty stack. And what that means is that, say, with Wi-Fi, if an owner has 10 Wi-Fi patents, then the judge has to take into account that there are 3,000 Wi-Fi patents out there, Wi-Fi standard essential patents. So if you are overly generous in compensating the owner of those 10 patents, then seriatim, every other standard essential patent owner also has the right to claim their compensation. So the royalty stack argument simply means that a judge must take into account the total number of standard essential patents in the mix when they figure out what the royalty rate should be.
Thank you, John. One more question, a side question on this. John was mentioning about this court to determine what is reasonable. Can there be an alternative? Can a user go to a competition commission and say that the royalty rates which are charged is so high, instead of going to the court, will the Competition Commission would have jurisdiction to decide the reasonableness or not?
Okay.